regard to I have gathered information from various sources, primary and secondary sources, such as books, legislations, statutes, and online journals and international journals. So, environmental impact assessment is a scientific tool to assess uh, the impacts of environmental damage or environmental concerns whenever a project is established in any part of the country. So, uh, so what are the significance of EIN in sustainable development? So EIA framework is the lifeline of environmental governance in any country, but in India, since its formulation, it is a weak and undemocratic framework of environmental governance. EIA is a scientific the cost and benefit of any project that has potential to cause harm to environment. Now, how it is undemocratic? Because it was passed in a very hasty manner. It was passed by a subordinate legislation notification. Government could have passed it by a proper mechanism of parliamentary procedure, but government has avoided these because of the discussion and debates. So, without discussion and debate, it was passed. So, it is undemocratic and in India, the public participation brings legitimacy to the whole process. But India, this stage is often gets ignored and neglected. So there are several stages of EIA, and I will cover their each step and their weaknesses. So first step is screening. Screening is the initial step. In this stage, a government or the authority first determine whether some project or particular project required, and the second state is scoping. In this process, uh, in this process, uh, the 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 extent and content of the EIA process should be discussed by the authority. That what are the issue that should be covered. Preparation of EO done by the proponent, that is the company that wants to develop the project. So, scoping is the process of determining the content and extent of matter which should be covered in the environmental information competent authority for which are AI in India, like gaps in regulations, weak implementation and isolation, and 2020 draft notification. There is a schedule, and in the schedule, certain projects are listed which required EIA uh, 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 EA process. EA process. So the schedule is categorized into two major categories, A and B. Categorization is an important mechanism. It is uh, through these mechanism, it is decided that whether uh, uh, EIA environmental clearance should be given or not given. So in the 2020 regulation, what the government has done, the government has excluded B2 from EIA process. And they are also reserved certain categories of projects, namely strategic. And we don't know what is the meaning of strategic by the government. So the government has uh, final say over what will be the strategy, and it gives a very broader power to the executive authorities. Now, when it comes to the weaknesses of the each process, the main problem that are attached with this process is that, particularly speaking about screening, even though some of the industrial projects do not require EIA as per the statutory norms, they might involve certain chemical processes which could be harmful to the environment and public health. If you look at the national statistics, most of the pollution done by the small scale industries, and they are exempted from it. Now, coming to the second stage, that is scoping, that is lack of exhaustive ecological and socioeconomic indicators for impact assessment, and an inadequate scoping phase can result in an EIA that is unfocused, omits key issues, do not address the concerns of the key stakeholder, and could hinder the decision-making process. Now, coming to the third stage, consultation and what are the gaps in regulations and how it is weak implemented in our country. So, authority who conducts public hearing has power to report that it is not possible to conduct public hearing. Had a provision to publicize widely the EIA report in the nearby village or in nearby city. But this provision has been removed from 2020 notification. And as per paragraph 14, clause 2 of the 2020 notification, certain projects are exempted from conducting public hearing at all. And this includes B2 projects, and B2 projects include chemical fertilizers, small scale industry. So government have given a certain leeway to the project proponent for this. So one of the biggest flaws in the 2006 and 2020 notification have been the failure to integrate EIA with other framework that form a part of environmental governance, other environmental laws. We cannot ignore in our country, tribal rights, tribal people rights. So Scheduled Tribes and Other Traditional Forest Dwellers Recognition and Forest Rights Act 2006, Biological Diversity 2002, Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. So there is no action from the government to integrate EIA framework with current framework. And the 2020 notification has also lost this opportunity to integrate these laws into EIA. Now coming to the EIA
Pooja
process.
Kumari, yeah, I think your time is up, so you can just wind up, and also your slides are not moving.
Yeah,
so,
just 1 minute. So how EIA process and judicial review, okay, I'll skip the part. How EIA process and judicial review in India can be done. So EIA process can be reviewed judicially by the court in India by 3 grounds: illegality, irrationality, and procedural impropriety. And what is the difference between EIA in India and other developed countries? EIA in developed countries, that in India doesn't give much due importance to public participation, whereas in USA, public participation is one of the essential component of EIA. Thank you so much.
Thank you, Pooja. Thank you for the wonderful presentation.
I request the chair if there are any questions. So,
Professor AP Singh, sir.
extremely sorry for the inconvenience.
Okay, so there was some network issue, not a problem. I think now the network has resumed. Parth, Shambhavi ma'am. Yeah.
Now we have our next presenter.
Hello, am I audible?
Yes, sir. Yes,
Am I
sir. Now
audible?
you're on.
So I
Yes,
just
sir.
wanted to once again put on record that you see, terming EIA as undemocratic would be slightly misconceived in the sense that it is done by way of a statutory process provided therefore. For example, I mean the powers available to the executive in terms of subordinate legislation under Environment Protection Act, this is done, right? So I mean obviously the legislature cannot pass every single rule for that purpose. So that way it's okay. Yeah, you see, the very fact that 2020 EIA has excluded public hearing in certain cases is something which goes against the very idea of EIA process, because public hearing is considered to be one of the essential components of EIA process. So that problem is there, and judicial intervention that she is suggesting is also slightly, I do not know if it is practical, because judiciary cannot really look into every single element like that. There have been a lot of PIL process in environmental matters, but nevertheless, the idea of exclusion of public hearing is something that should have been challenged in a court of law. That's the only point I would like to make.
Right.
Thank you. Go ahead with the next speaker.
Right. Yes. Parth, please.
Yes. Now we have our next presenters, Dr. Sanurani Paul and Ms. Puneet Dhanova, presenting on judicial stand on ecocentrism and analysis.
Dr. Sanu, is she
Dr.
there?
Sanurani, I think she's not there. We have checked.
Because earlier also we called her name, she wasn't there, right?
Coming
Mr.
up with
Puneet is
Parth,
also not seen
some
in
problem
this.
with her. Either
Right.
she's not there or connection, I mean, connectivity is not there. I think we can proceed on to the next speaker.
I think
Coming up
Dr.
with
Dr.
next
Sanu, are you there? Dr. Sanu, are you there? She's not there.
Yes, sir.
Proceed to the next speaker.
Coming up with
Parth.
the next presentation, I invite Dr. Pranjay Paramita Panda, and I hope I'm not pronouncing it right, and Mr. Tanvir Raj Padi.
Hello, am I audible?
Yes, ma'am.
Yes, ma'am.
Hello,
Dr. Prajay.
this is Pragya Paramita Panda.
Acha, Pragya.
Pragya.
Okay.
Yes, sir. Yes, sir. Sir,
Dr.
just a
Pragya.
second. Yes, sir. So, no. So let me share my screen. Just a second, sir.
Please proceed. Please proceed.
Sir, please. So just a second. Hello. So please, sir, just a second. I'm facing a little bit problem in sharing my screen.
Please share. Please share.
Sir. Thank you, sir. Ma'am, can you help me out for this?
Ma'am, are you facing a problem with screen sharing?
Yes, ma'am.
Dr. Pragya, maybe we can call you just next presentation. Meanwhile, we can work out with your screen sharing.
Okay then, ma'am.
If that's okay with you. All right.
Okay then.
Parth, please move on to the next presenter, and then we can call Dr. Pragya back.
Proceeding with the next presentation, Mr. Aman Karan with this paper themed on the critique of anthropocentrism, a new idea of sustainability.
Yes, just a second. I'm sharing my screen. Is it visible?
Yes,
Yeah.
sir.
Yes, the screen is visible. Speakers are also requested to
Am I
switch on their
visible?
cameras. Yeah.
Aman, you are visible, but yeah, your screen is there now.
Okay. Good afternoon, participants, chair of the session, and all the attendees of the session. My name is Aman Karan, and I'm going to present on the critique of anthropocentrism and a new idea of sustainability that can be derived from it. To begin with, anthropocentrism in the simplest term can mean human centeredness. It is defined as the belief that regards human beings as the most important life form. Basically, it says that it advocates that human life has intrinsic value while other life forms, such as plants and animals, have only instrumental value. In the context of environmental sustainability, this critique is important because the current idea of sustainability is based on this anthropocentric or this instrumental view. Environmental sustainability refers to responsibility of preserving and protecting the ecosystem and natural resources for present and future generations. The parochialism of environmental sustainability. Parochialism means narrow-mindedness. And the idea of sustainability is parochial in the sense that the belief of anthropocentrism is deeply embedded in this idea. Various commissions, charters, and agencies define sustainability in more or less the same way. That is, uh, they define it as protecting and preserving the environment to meet the needs of humankind's present and future generations. This meaning, this idea of environmental sustainability has limited its scope. This idea to mean only preserving the environment for human beings. This definition feeds to the instrumentalist view, and this narrative leads to conservation of environment not for environment's sake, but for the sake of humanity. This is why an exhaustive and comprehensive idea of sustainability is necessary. Understanding environmental philosophies is necessary since different philosophies propounds a different idea of sustainability. For example, the current idea of sustainability is based around anthropocentrism, as we have discussed earlier. Types of environmental philosophies. There are various types of environmental philosophies. Some of these types are anthropocentrism, as we have discussed above, is in the form of non-anthropocentrism, which can also be called nature-centeredness. Non-anthropocentrism advocates that even plants have intrinsic value since they have their own needs, such as the need for air, sunlight, water, etc. An idea of sustainability that is derived from non-anthropocentrism will be a virtuous one, but it will be biased against human beings, since non-anthropocentrism puts the other life forms above human beings. There is another environmental philosophy known as ecocentrism, which we'll be discussing further, where anthropocentrism assigns moral and intrinsic value exclusively to human beings, and non-anthropocentrism assigns moral and intrinsic value to natural objects and plants. Ecocentrism is the belief that assigns these moral values and intrinsic values to all objects existing in nature, whether it be biotic or abiotic, or sentient or non-sentient, which is why it is also regarded as an ideal for sustainability, as it compels recognition of humanity's moral duties towards nature. The idea of sustainability in the ecocentric view proves to be more comprehensive, as it considers all organisms and their habitat as important and crucial to sustain. So what will be a new idea of sustainability? In a paper published in the Ecological Citizen titled Why Ecocentrism is a Key Pathway to Sustainability, the authors argued for ecocentric sustainability. They based their arguments on ethical, evolutionary, spiritual, and ecological grounds. Ethically, it was argued that since ecocentrism expands moral community from only human beings to also other life forms, it will be unethical to use other life forms as just instrumental, as just tools to survive. On evolutionary grounds, it was contended that since human beings has evolved from this ecosystem, an idea of sustainability that is based around preserving this ecosystem will be an ideal one. In spiritual and religious terms, it was argued that many religions regard no, many religions regard non-violence to inanimate objects as the pathway to attain enlightenment. So these religions, just like Jainism and other religions, also account for ecocentric sustainability. Ecologically, it was put forth that ecocentrism, since this ecosystem connects all life forms, an idea of sustainability that will be protecting this ecosystem should be more preferable than an anthropocentric sustainability. The inclusive nature of ecocentrism proves to be beneficial for both human beings and environment in the long run. Sustainability, then, in an ecocentric view, can be simply defined as preserving the environment and nature for human beings, plants, animals, and other life forms, sentient or not sentient, and biotic or abiotic, without compromising ecosystem at large. To conclude, ecocentric environmental sustainability means sustainability where environment and nature are preserved without compromising the ecosystem at large. Ecocentrism plays a role in indicating collective responsibility or responsibility of humankind as a community to be empathetic towards other life forms. It is an ideal theory of sustainability, but because it is ideal, it becomes difficult to follow. Carl Jung, a Swiss psychoanalyst, said that every form of addiction is bad, no matter whether the narcotic be alcohol, morphine, or idealism. What he meant by this is that chasing idealism can be worthless since it is based around perfection. The collective responsibility that ecocentrism induces. To conclude, even if ecocentrism is an ideal, practicing sustainability just in the ambit of this belief would be suffice for the time being. What is necessary is the shift from anthropocentric principles to ecocentric principles. Thank you.
Aman, the idea of eco-central architecture of
Yes, sir.
international and national environmental protection regime
Yes,
is
sir.
based on, you see, as Article 15 of CBD would put it, that man is, you see, the center of this entire legal process.
Yes, sir.
So, the idea of anthropocentrism is inbuilt in the current legal regime.
Okay.
So, changing the whole paradigm of environmental lawmaking, national, international, doesn't matter, requires a new understanding. Bhagavad Gita had
Yes.
this, what you are talking about in chapter 3, you can look into slok 9, 10, 11, Sahyagya Prajasvasta Purovacha Prajapati,
Yes,
etc. So you have that kind of anthropocentrism, Indian tradition, but that is something that has become thing of the past, and we have borrowed now, you see, the Western principles to
Yes.
govern ourselves in every walk of life. But nevertheless, wonderful presentation by any standard. Thank you. Thank you. Parth, we can move on to the next speaker. If Dr. Pragya is now able to connect, she can be brought in.
Aman, currently stop sharing your screen as well. Thank you.
No. Parth is also probably non-communicative right now.
Dr.
So
Pragya,
we'll move on.
Yes, ma'am.
are you able to resolve
I'm
your
here.
problem? Is your problem resolved?
Can you help me, ma'am?
Yes, ma'am.
Actually, I am not
Aman,
able to share my
Karan,
screen.
please stop sharing the screen.
Yes, ma'am. Sorry, ma'am. Is it fine now?
Yes, now it is fine.
Yes.
Yeah, Dr. Pragya, try now.
Okay. Yes, ma'am. Just a second. Yes. Okay. Is it visible now, ma'am?
I think
it is
something
visible.
has changed. Right.
Yes.
Okay.
Yes.
Okay. Thank you, ma'am. Can I start, sir?
Please proceed.
Thank you, sir. Art provides enough to satisfy every man's need, but not every man's greed. A very warm afternoon to all the esteemed jury members, organizing committee, and all the participants present over here through the wave. This is Dr. Pragya Panda, Assistant Professor, Rourkela Law College, present over here for a presentation on the topic, Role of Judiciary in Protecting Environment. My topic deals with these things such as what is environment, what is pollution, types of pollution, objective and hypothesis, concerns of judiciary, conclusion and suggestion. So, before starting this subject, First, let me focus on the point, what is environment? And when we say human being and environment, their relation with each other are just inseparable. Without one, the other is just impossible to exist. And for that, what happened? But due to this modernization, urbanization, or rather we can say digitalization, man just forget about the concept of environment and do whatever he or she wants. And ultimately, the nature sometimes shows us its destruction and due to only because of pollution. And the next point is that what is environment pollution? When we say pollution, that is contamination of physical and biological components of the earth to such an extent that normal environmental procedure is adversely affected. And if we focus on the reasons of environmental pollution, as we all know that there are various reasons such as population growth, deforestation, urbanization, and research and development, etc. And next types of just a second. So, mm, next is types of environment pollution. If we focus these categories of environmental pollution, majorly are focused this air pollution, water pollution, and soil pollution. These are the three major factors which are polluted nowadays highly, and the effect of those pollution are just destructive in nature in nowadays. Next, various reasons like trade effluent from factories and urbanization, as I am earlier discussed. And the next is objective of this study. This objective in this presentation is that to analyze the role of judiciary. Basically, sir, I am here to focus on the role of judiciary and the interpretation of various doctrines, mainly for the sake of protection of environment. And as in this 21st century, the concept of environment is highly important. And we can say that in near future, the whole globe can be destroyed within a second. And we people are just neglect these things as this environmental pollution act like a slow poison. So we are now just neglecting those factors, and we are now focused totally on this developmental factor rather than this ecological factor. Why I'm saying, because we are hankering after this digitalization and this urbanization or modernization, and without thinking about, without maintaining the balance between this sustainable development. And a hypothesis of my study with judiciary through the mechanism of judicial activism, PIL, and other doctrines always play a very vital role to protect the environment. And now the point is that if suppose environment is highly polluted and sustainable balance is not maintained and all that thing, then whether our world or even our India is just silently stand as a spectator, the answer is no. There are so much that rather we can say that plethora of stringent laws in our country. There are provisions to fight with this environmental pollution, such as constitutional provision, international provision, special legislation. As my previous presenter already elaborately mentioned, special provisions and the role of judiciary and PIL and judicial activism. Why I'm saying this PIL and judicial activism? Judiciary are the most important organ, and it is not wrong if I am saying that the judiciary as a real fighter nowadays through its mechanism, through its weapon known as PIL and judicial activism play a very active role in protecting our environment through different case laws and through different doctrines. And as time constraint is here, so I am not elaborately mention all the doctrines. Just I'm focused on this intergenerational equity doctrine, in which our judiciary, in a case Himachal Pradesh versus Ganesh in the year 1996, the Supreme Court mentioned the importance of intergenerational equity, and in Andhra Pradesh Pollution Board versus MB Naidu in the year 1992, the court said about the right of the future generation of a healthy and hygienic atmosphere. And if we people in the present generation, with suppose forget about the future generation, then certainly we cannot expect the healthy atmosphere for our future generation, that may be of our children or grandchildren, etc. Then next, precautionary principle. As in our country, precautionary principle focused highly or adopted highly, because in our country the concept is that prevention is better than cure. Aim is to protect the environment from all the activities which threaten the preservation of our environment. And next one is polluters pay principle, and this one is a very good principle or very active principle if it is interpreted strictly. Then, so in this principle, what happened? Our Supreme Court judiciary uh, make liable to the polluter for all the damages whatever done by him or her or by any corporation, any company, whatever. And along with that, the polluter has also pays the damages to the victim. And next is absolute liability. And when we say absolute liability, this means what? This liability is without any defense or without any exemption. And in the case of Union Carbide Corporation versus Union of India in the year 1990, this absolute principle is implemented, or the Supreme Court or the judiciary focused on that. And when we say judiciary, role of judiciary, there is a new jurisprudence nowadays in 21st century emerged, that is known as environmental jurisprudence. And next, as you all people know that PIL, public interest litigation cases, which are strictly deal with this pollution of environment, Justice PN Bhagwati and Justice Krishna Iyer was the first judges to accept these PIL cases. In Sriram Food fertilizer cases, the Supreme Court directed to the company to adopt all the necessary safety measures before starting any company or corporations. And as time manager has already messaged me, he is time constraint. So let me focus on this conclusion and suggestion. So the judiciary has established, to conclude, I can say that the judiciary has established a strong jurisprudence as a base of environmental concern on and the focus is on sustainable development, as it is the need of the hour. And to from my side, there are certain suggestions such as balance between ecology and development, awareness should be created, mindset must be changed, environmental education should be provided, and the last and most important, accountability of administration should be strengthened. And within a quote, I can mention that judicial activism should not so powerful that it always putting its foot in the shoes of executive, rather it should act as an emergency lab. Thank you very much, sir. Thank you. Hello.
Thank you, Dr. Pragya.
Thank you,
Very
sir.
well. Any questions that if there are no questions, we can move on to the next speaker, Parth.
Yes, sir. We can move on to the next speaker. Yeah.
Now we have
Thank
Ms.
you, sir. Thank you very
Priyansha
much.
Badoni. Thank you, ma'am. Now we have Ms. Priyansha Badoni.
Stop sharing the screen, Dr. Pragya. Yeah, thank you. Proceed, Parth.
Now we have Ms. Priyansha Badoni and Dr. Fezarur Rahman presenting on settling green disputes through arbitration.
Thank you, Parth. A very good afternoon to Dr. A.P. Singh, sir, Dr. Garima, and Ms. Shambhavi. I am Priyansha Badoni, and I have submitted a paper titled Settling Green Disputes Through Arbitration, along with my supervisor, Dr. Fezarur Rahman. We are from Jamia Millia Islamia. In my paper, I don't have a presentation to share, so I'll be speaking regarding what is it that I have mentioned in my paper. So environment should be of utmost concern to humanity. Sadly, is amongst the least of our priorities as a community. However, in the recent times, we can say that there is a renewed awareness, a consciousness, because we have suffered so much due to our actions, that we are now looking for new ways of dealing with environmental concerns. Environmental issues are as such that it needs a holistic approach for their addressal. Now, when I say holistic approach, what do I exactly mean? Community as such, members of the community, for example, the scientists are finding out new ways in which they are figuring out how the interaction of humans can change with environment in such a way that environment is not badly affected. Civil activists in the society have a different role to play, as in they are ensuring that the government, whatever action they are taking, are environment conscious. The corporates now are becoming environmental conscious in their actions. So what as lawyers do we do? As lawyers, we are figuring out ways and methods in which how we can quickly dispose of any matter which is concerning environment. There is a renewed consciousness as to we cannot let environmental matters stay piled up in the court machinery, because as the time passes by and if no decision has taken, the effect on the environment due to human activities is bad, and till if we keep waiting for the decision, it stays on, right? So in India especially, we can say that our constitution itself reflects that how environment conscious we are as a society. Our traditional practices are environmental friendly, but on our way, on our path to development, rather speedy development that we desired for, somewhere environment as our concern received a setback. So in our paper, we have mentioned that how it is not just the judiciary, but judiciary which has helped, Indian judiciary has contributed to jurisprudential aspect by bringing out so many principles such as the polluters pay principle, precautionary principle, and has tried its best for ensuring environmental preservation in our country. Establishment of NGT through the NGT Act was an important step in conservation of environment, but in the present times, it is being observed that the system of tribunalization of justice in our country is something that we are now reviewing, that has it served the society well. So when we are questioning the systems which are already established, what is called is that we start looking for new ways. Then how do we resolve problems concerning environment? Arbitration, we propose, can help in this area. How? Arbitration, first of all, being a specialized way of resolving any dispute. Your dispute concerning environment does not get locked up in the long litigation machinery, but is rather resolved through experts. So it could be a scientist who is presiding over the matter and is better suited to give a decision relating to an environmental concern. Then of course it is speedier as compared to litigation, and then it is considered to be cost effective also. Moreover, how arbitration can become non-suitable. There's one point everybody says that it's a confidential process. So how will you invite society in arbitration proceedings when ultimately any environmental concern is a community concern? So arbitration also has such methodologies, such as inviting for amicus curiae and third-party participation, in which even public representation can take part in confidential process of arbitration, right? So so it is a good way in which environmental concerns can be addressed quickly through specialized disposal of environmental disputes. And in fact, during the pandemic time, when courts world over were shut, it was arbitration that could be easily or rather smoothly be conducted through online mechanism, and any dispute which was being redressed through arbitration did not receive this setback of not being addressed in a physical setup. Then speaking about international forums, there are many international forums who have already started accounting for arbitration as a method of resolving any environmental concern. For example, the Permanent Court of Arbitration has already made relevant changes in their rule to incorporate procedure for arbitrating environmental disputes. In November 2019, the ICC, International Chamber of Commerce, has also published a report in which they're promoting that let us focus now on arbitration as the method of resolving a dispute. And the UN Convention on Law of the Sea also contains arbitration as a dispute resolution mechanism. If you remember that the dispute between China and Indonesia regarding certain islands was in fact resolved by United Nations Convention on Law of the Sea through arbitration, right? So to conclude my presentation, environmental concerns being community concerns and requiring our immediate attention rather than resolving through them through a tedious established methods of litigation or through tribunalization. It is better that we switch to the new methods such as arbitration and expect rather work towards quick disposal of such concerns.
Priyansha, thank you.
I believe Priyansha has done well in highlighting the importance of arbitration in environmental dispute resolution process. If there are no questions, we can move on to the last speaker, if I'm not wrong, because 9 speakers is what I was given to understand. Yeah.
Yes.
Parth, over to you, beta.
Thank you so much. Thank you.
God bless you, beta. God bless you.
Here we are with our last presentation, Mr. Rahul Kumar with his
Good morning, respected panel. Environmental quality in such a situation, how the judiciary can acquire high importance and has become a matter of caution and judicial notice. It is a gospel truth that the more than administrative and legislative nature judicial activism supposed by PIL has served the cause of anti-pollution, environmental protection, and maintenance of ecological balance. Then there's environmental protection by analyzing. There's a section of section 133 of CRPC where the executive magistrate can approach for order for removal of public nuisance. This was not effective. This section come in more effective in the case of Govind Singh versus Santu Solar. Then there is judicial activism on sustainable development. In the case of Vellore Citizen Welfare of India, the Supreme Court held that there is no hesitation in holding the sustainable development has been accepted as a part of customary international law. Those features have to be finalized by international law jurists. The Supreme Court in this matter have certain significant direction for implementation of two principles, namely precautionary principle and polluter pay principle, aimed at reserving the damage caused to the ecology and environment and determining the compensation payable to the individual families who have suffered because of pollution. Then what is the precautionary response? The Supreme Court in Vellore Citizen Welfare Forum has organized the precautionary response. The Supreme Court has reiterated again in the case of MC lack of environmental degradation, where there are lack of scientific in 1970, when there was a great public interest in environmental issues. During this time, there was a demand of government and other institutions to introduce policy and mechanism for the protection of environment and the public forum the threat posed by the pollution in modern industrialized society. Since then, there has been a considerable discussion on the nature of polluter principle, but the precise scope of the principle and its implication for those involved in past or potential for polluting activities had never been satisfactorily agreed. Then there's the last, public trust doctrine. This doctrine, which found its way in the ancient Rome Empire, primarily rests on the principle that certain resources like air, sea, water, and forest have a great importance to the people as a whole, that it would be wholly unjustified to make them a subject of private ownership. The said resources, being a gift of the nature, should be made freely available to everyone, irrespective of their status in life. The doctrine enjoins upon the government and its instrumentalities to protect the resources of the enjoyment of the public. In the case of MC Mehta versus Kamal Nath, the Supreme Court dealt with the elite trust doctrine in great details. The court observed that the public trust doctrine primarily rests on the principle that certain resources like air, sea, water, and forest have such a great importance to the people as a whole that it would be wholly unjustified to make them a subject of private ownership. The said resources, being a gift of the nature, they should be made freely available to everyone, irrespective of their status in life. The doctrine enjoy the government to protect the resources of the enjoyment of the general public. They concerning environment and ecology. This principle must be applied in a full force for protecting the nature resources of the country. The situation seems to be destinated for doom the industry rapidly cleared, and the environmental agency could not be really bring their weight to bear upon the industry. The industry classically represents the case too powerfully dependent who continues to flex their muscles, ignoring and degradation of environment caused by the industries. Such muscles firing in common in a soft status where the majesty of a law is often compromised or considered status as well. In new economic order is industry development. Nation status is dependent upon economy. In order to improve economic status, every country strives to boost the industrial development. This is the reason why the massive industries are tree industries increasing day by day. Ultimately, it creates a threat to the all things into existing rapidly. As a continuous of this situation, hazardous activity of living beings on the earth. To control this grisly situation, we need environmental justice. As environmental justice should be with flexibility, the flexible way to the environmental justice is public interest litigation. Though this public interest litigation, any interested person on behalf of the public can approach to the court of the environment. Thank you.
Thank you, sir. I request the chair if they have any
Thank you, Mr.
questions.
Rahul. Well presented judiciary contribution. Do we have any questions or observations? Dr. Garima, would you like to say? I invite you to make your observations on presentations that we had.
Right, sir. So, sir, I believe that all the presenters have done a good job. They have highlighted the role of the judiciary with respect to the sustainable development. And indeed, the Indian judiciary has since long taken care of the environment. And now we have the NGT also, which is working towards the environment protection. Indeed, with respect to one paper, that is Pooja Kumari, critique of EIA notification 2020, you have rightly pointed out that obviously delegated legislation has to be there, but at the same time, more can be done with respect to public participation. When it comes
excuse me, ma'am. Mr. Rahul, can you stop making presentation and stop presentation?
Okay, yeah.
So that we have a bigger screen to interact.
Right, sir.
Sorry. Yeah, right. Please proceed, ma'am. Sorry.
So with respect to all the papers, I'm very happy that good points have been raised. I especially appreciate Pooja Kumari with respect to her paper. Obviously, the points made were relevant, and sir has also rightly pointed out that with respect to making of laws, some powers have to be delegated. But at the same time, whatever is best for the environment should be considered, and we cannot ignore the environment. Of course, environment is something wherein we are living. We are breathing the environment. We are eating. Everything that we do is connected to the environment, and we are part of the environment. So with respect to that, I am really happy that some very good papers have been presented, very good ideas have been shared, and each of the speaker has brought to the table some good aspects of the role of judiciary. Again, with respect to Priyansha ma'am, I believe that the scope of arbitration can be further explored, and obviously judiciary cannot be overburdened every time. And wherever possible, arbitration can be taken as a route. So with respect to each and every participant, thank you so much. And I really wish that you work on your papers and you get them published and further improve them. Thank you. Thank you, sir. Over to you.
Thank you, Dr. Garima, for very precise but pointed observations on the papers presented by 7 speakers, right? We had 7 speakers in this session.
Yes.
And for whatever reasons, I have been commenting on the papers immediately after the presentation. So I have already made some of the remarks on, you see, this particular session, emerging judicial landscape of environmental sustainability. Well, the first thing that I do is to congratulate the organizers for picking up a very useful topic. And about emerging judicial landscape, by way of my remarks, general remarks, as I would put it, you see, my understanding is that, you see, during last, say, start from 1950 onwards, for 30-40 years, you had no word from the judiciary. Then during 90s, 80s and 1990s, judiciary was absolutely activist in coming up with some, you see, astounding judgments and building up a whole new world of what we call environmental jurisprudence in India for really 20-25 years or something. And some wonderful principles were established for the purpose of environmental governance. But during last 10-15 years, there hasn't been a major change in judicial approaches. So to me, it appears that, you see, what we had evolved during 1980s and 1990s has become the guiding light for us to follow now. Not much has been added to this. What all I appreciate and understand is that you see the principles that were evolved during 1980s and 1990s, they were like all principles in terms of, but lacking in value, of implementation process. So judiciary had developed the habit of commenting on variety of principles, but not taking into consideration, you see, the legislation on the subject and their implementability. So most of them were the statement of principles. Probably now is the time that we start implementing those principles that judiciary has evolved. So that is the kind of a task that we have, and the presenters that have you see presented their papers in this last 1.5 hour, over 1.5 hour, 1 hour 40 minutes, so to say, they have actually made out those practical issues whereby those principles can now be implemented. So therefore, each speaker, without naming each one of them, because Dr. Garima has already addressed these presenters by their name and you see highlighted their contribution, I would congratulate each one of you for highlighting a practical point of view, which in terms of principle has been constructed by the judiciary earlier, but now is the time for us to, you see, come up with those ideas whereby we can really implement them in practice. So congratulations to all the presenters. And I also take this opportunity to put on record my sincere gratitude and thanks for inviting me to chair this session and also learn a few things from my young friends. Thank you so much. All the very best. Over to you, Parth.
Thank you so much, sir, for enlightening all of us and honoring us with your presence. I'm extremely sorry for the inconvenience caused. Thank you, everybody, for joining in on this discussion and making it a very fruitful and knowledgeable one. On this note, our second technical session for the International Symposium comes to an end. We are grateful to have with us as our chairs, Professor Dr. A.P. Singh, sir, and Dr. Garima Goswami, ma'am. We are beholden to all the presenters who have presented exceptionally. Thank you to all the audience for sitting through these exciting presentations. You were a great audience. A very big thank you to the organizers finally, whole special events committee, coordinator, co-host, reporters, Zoom management team, and everyone who made this session a successful one. With this, we conclude the event. Thank you for joining us. You may stay back to record your attendance by filling in the link posted in the chat box. Stay safe, everyone, and have a nice day.
Thank you.
Thank you so much.
Professor AP Singh, sir. Thank you so much. It was a pleasure
Thank you,
sharing
Dr.
the
Garima.
session with you. Thank you so much.
Thank you. I can leave now, I hope.
Yes, sir. You have a commitment.
Thank you so
much for sparing time. Thank you, sir.
Thank you so much.
Thank you. So I think I can also leave.
Yes, yes. Thank you so much,
recording can be
Dr.
stopped.
Garima.
Thank you, ma'am. I think recording can be stopped. Good morning.
Good morning. Good morning. Very good morning. So how many speakers do we have for the session?
I believe there are 9 speakers for this session.
Okay.
So, so Parth, who is hosting, you shall be moderating, or is there a faculty moderator? Parth Agarwal. So I think we'll just take a few minutes to sort out things.
This is something that I informed Dr. Ravikant Swami as well. That at 2 o'clock I have a very important engagement in VC boardroom. So 1:50, 55 I will have to leave.
Sure. So we'll try
have to plan it
up.
that way that we are through by 1:45, 1:50.
Right. Right. Shambhavi ma'am. I think there's some problem. Wait. So I'll just open the session list.
I hope I'm audible now.
Yes, yes. Now you're audible. As Professor Dr. AP Singh has another engagement, so accordingly we'll manage the time.
Parth, I think we can begin then.
I believe Parth, is it over to you? Please start, beta.
A very good afternoon to one and all present here. I'm Parth Agarwal, host for this session on behalf of my hardworking team, and this institution, Delhi Metropolitan Education, takes this opportunity to welcome you all at the session of International Symposium on Deliberations on Rethinking the Environment Sustainability in Modern Era. This is technical session 2 titled Emerging Judicial Landscape of Environmental Sustainability. All, I would like to extend a warm welcome to the respected chairs of the session, Professor Dr. AP Singh, sir, and Dr. Garima Goswami, ma'am. Professor Dr. AP Singh is Dean, University School of Law and Legal Studies, GGSIP University, Delhi. He holds 3 master degrees in Constitutional Law from MDS University, Ajmer, Legal Theory from European Academy of Legal Theory, Belgium, and English from Meerut University. Specializes in constitutional law, environmental law, and legal philosophy. He has around 25 years of experience in teaching and research. He has got 4 books and 52 papers published, delivered over 100 lectures in universities in India and abroad, and is working member of ILI, ISIL, and IIPA. We welcome you, sir, and we are delighted to have you with us. We also have Dr. Garima Goswami, ma'am. Dr. Garima Goswami is Associate Professor of Law, DME Law School, Noida. She pursued her graduation from GGSIP University, Delhi, post-graduation from Indian Law Institute, Delhi, and doctorate from Jamia Millia Islamia. Her doctorate is based on the theme of cybercrime against women. She has authored several articles in reputed national peer-reviewed and UGC care-listed journals. She has presented several research papers in international and national conferences and seminars. We welcome you, ma'am. We are delighted to have you. Before beginning, I wish to inform all the participants that the total time allotted to the speakers of a paper is 10 minutes. The speaker shall be allotted 8 minutes for presenting, and the remaining 2 shall be for questions by chair. While one presentation is going on, other participants are requested to keep their microphones on mute. In case of any glitches, kindly contact the concerned technical support. With due permission from our respected chairs, we'll be beginning with the presentations. Wishing a very best of luck to all the presenters. To kickstart this session, we have our first presenter, Ms. Priyadarshini Goenka, with a presentation on sustainable development and activism role of Indian judiciary and analysis under Indo-international diaspora. Ms. Priyadarshini Goenka.
Am I audible?
Yes, ma'am. I request you to switch on your video, please.
Okay, just a second. Shall I share my screen? It is visible right now. So before moving on to the significant relevance of the topic, it becomes important to understand the concept of sustainable development and in what way the Indian judiciary has ensured protection against environmental degradation. As far as the protection of life of human beings, including other living organisms, from the hazardous consequences of pollution, right to life as guaranteed under Article 21 of the Constitution of India has been interpreted very effectively and liberally by the Supreme Court and various other state high courts, and such provisions have been invoked by the judiciary within its scope. The inherent expression sustainable development implies integrated human developmental strategies with minimum adverse effect on the environment. The concept was well articulated by the World Commission on Environment and Development 1987 in its report, which is popularly referred to as the Brundtland Report. The concept has also been internationally recognized at an international conference, the UN Conference on Environment and Development, also known as the Earth Summit, which was actually held at Rio de Janeiro in Brazil in June 1992. It was also be mentioned that the concept has been explicitly invoked by the Supreme Court in Cheta Pradesh Mukti Sangharsh Samiti's case, ultimately considering the acceptance of development, the balancing concept between ecology and development as part of customary international law. Sustainable development, the concept in international perspective. The term was used at the time of the Declaration on Environment and Development back in the international organizations dedicated to achieving environmentally being or static actively participated in it and agreed on the declaration of principles. Next, we have the Montreal Protocol, which came into force from 14th January 1989 and aimed at the elimination of ozone depletion circumstances. The pact was signed by 48 nations, and India, along with the other developing nations like Malaysia and China, refused to sign it because of pragmatic considerations and discriminatory clauses. The Brundtland Commission and Sustainable Development. The very term sustainable development was actually brought to common use by the World Commission on Environment and Development. In its seminal report 1987, the report provided a comprehensive development as a development that meets the needs of the present. According to the Brundtland report, critical objectives for environment and developmental policies followed from the concept, including growth, changing quality of growth, meeting essential needs of people, food, energy, water, and situation. UN Commission on Sustainable Development, in its functional commission of the UN Economic and Social Council, which originated from Chapter 38 of Agenda 21, one of the most extensive documents of the Rio Summit, which actually acted following the principle of equitable geographical distribution to ensure a balance between the continents and between the developed and developable development. The concept has grown its inception in the international flora and acquired different dimensions in terms of economic growth. Talking of the intergenerational equity, the central focus point of intergenerational equity theory is the right which is possessed by each generation of human beings to benefit from the cultural and natural inheritance of the use and conservation of natural resources. The idea for the benefit that the future generations and present generations should be modest in their explanation of natural resources. In the case of consumers and civil action group versus Union of India, the court extensively observed social accountability in the matter of protection of the environment. Furthermore, the precautionary principle's main purpose is to ensure that any substance or activity possessing a threat to the environment can be prevented from adversely affecting the environmental standards, even if there is no conclusive scientific proof. And lastly, the polluter pays principle has referred to the absolute liability for harm to the environment, extending not only to compensation, but also to the cost of restoring. Role of the judiciary in order to implement the environment and sustainable development. In India, unlike any other developing country, there has been various degradation, exploitation, depletion, and industrialization. In real times, India has always been at the forefront of taking all the possible steps for the protection and improvement of the environment. At the same time, the judiciary plays a pivotal role in interpreting the laws in a manner that not only helps in protecting the environment, but also promoting sustainable development. The judiciary has created a new concept of environmental protection that has shaped a very important role in development while deciding further cases. Citizen Welfare Forum case, the Supreme Court had taken a moment was set up, which was Mr. Brundtland, the Prime Minister of Norway's detailed report, usually referred to as the Our Common Future, popularly recognized as Brundtland report. In another very recent case, Intellectual Forum Tirupati versus State of Andhra Pradesh and others, the Supreme Court once again considered the doctrine regarding preservation and conservation of natural resources. Above extensive way, the Indian judiciary has played an effective role by introducing a new concept of sustainable development in the Indian legal system to deal with environmental maladies under the economic development of the country. By introducing such concepts, the judiciary has been trying to maintain a balance between two variables in connection with the persisting environmental issues such as developmental protection and environmental protection. Thank you.
Thank you, ma'am. I request the chairs if they have any questions, they may ask.
Yes. Professor AP Singh, sir.
I believe we can, I mean, if somebody else asks a question, we can reserve this time towards the end of the session when everybody has spoken.
Yes, sir, we can do that.
Immediately.
Or we have 9 papers, so we have given some 8 minutes for the presentation, and then 2 minutes we can give our observations as you're comfortable.
Okay.
Sir. Yeah.
Okay.
Right,
So let's move on to the second speaker.
Sure, sir.
Yeah, please proceed, Parth, please.
Coming up next, we have Mr. Rahul Kumar with his paper titled on Judiciary on Sustainable Development of Environment.
Is it that Rahul Kumar is there around?
We can move to the next one, to the third speaker, in case Rahul is not.
Move to the next part, yes.
Yeah.
Next up, we have Ms. Ayushi Soni and Mr. Suresh Sharma presenting their paper on Strengthening Environmental Governance, a Way Forward for Environmental Sustainability.
Am I audible?
Yes.
Ma'am?
Yeah.
Yes.
Okay. Am I visible also? Can you also please check?
Yes.
I would request my co-author to present the PPT. Am I audible?
Yes.
Just, Judge, can you please give me a minute? I'll start in a minute.
I would request all the participants to please share their PPTs in full screen. Thank you so much.
So shall I start? Okay.
Yes, please.
So-
Just put the PPT in the full screen mode.
And the PPT appears to be on 6th or 7th slide, in fact.
Yeah. It's
To
not
the
on the
first slide. Yeah.
So there is some network issue. It will be there in a minute.
Okay. Meanwhile, we can check up if Rahul is there or not.
Shall I start?
Please start, beta.
Yeah, please start.
Okay. So good afternoon to everyone present. This is Ayushi Soni, a third-year law student from Himachal Pradesh National Law University. Today, my co-author Sri Sharma. Can someone please mute? I cannot.
Shambhavi ma'am, I think
so much noise coming.
Yeah, thank you. Yeah, please.
Thank you so much. So today, my co-author Sri Sharma and I will be presenting in this international conference on the topic Strengthening Environmental Governance, a way forward for environmental sustainability. By the end of the presentation, we'll know that what is India's progress towards environmental sustainability, and the answer to the question that though there exist laws and tribunals, why there exists a need to strengthen environmental governance for the environmental sustainability. When we talk about environmental sustainability, it is the responsibility to conserve natural resources and to protect global ecosystem to support the health and well-being of all the individual for now and in the future. Other way around, if we speak, it is meeting today's need without compromising the ability of the future generation to meet their needs. In the current times, using concepts such as sustainable development, polluter pays, public interest doctrine, these are the Supreme Court has raised the right of to the level of basic human right under Article 21 of the Constitution. Environmental governance in India has taken a positive step forward as a result of the dynamic judicial activism. when for Green Constitution, from the date we got our independence to the date we are here in 2022, India has grown significantly to protect the right and interests of the citizen and has grown in its environmental jurisprudence. Earlier, earlier when Indian Constitution was made, it was highly weighted towards business and property rights, and leaving little opportunity towards the environmental preservation. But when in 1976, 42nd Amendment Act came in, and Article 48A and 51AG, which talks about protection of environment and environment regarding of forest life. 51G talks about to protect and improve the natural environment, including forest, lakes, river, wildlife. We have come a way forward. There have been precedent, and judicial. The Supreme Court has crafted a green constitutional law. If we talk about Ryland versus Fletcher case that talks about strict liability, MC Mehta versus Union of India, which that was a gas leakage case that if someone engages in a hazardous and inherently activity, the person has to pay. There is PIL, public interest litigation, that can be filed in public interest when there is an harm to the environment and a public at large is affected. So there exists National Green Tribunal to address to the environmental issues. We have come a way forward, a significant contribution to the endeavor to conserve and protect the environment can be seen through the constitutional commitments. So when there are tribunals, when there are precedent, why haven't we achieved the environmental sustainability? Why are we here thinking about environmental sustainability? Through this paper, we have researched that there is need for issue and reforms to in the periphery of environmental government to achieve to the environmental sustainability, and which will be dealt by my co-author.
Okay, and your slides are also not moving, so just in case you can look into that. Thank you. Yeah. The second speaker.
Am I perfectly audible and visible?
Yes. Yes.
Okay, so I would be talking about that the various reforms which are needed in National Green Tribunal and what are the various issues pertaining to the same. So the first is that there is confrontations between the government and the NGT. In the recent past, National Green Tribunal has passed various orders which the government has which the government has find that is in the conflict of interests of the government. The Ministry of Environment and Forests has often accused the NGT of overstepping its jurisdiction by pronouncing decisions which are beyond its scope. So one of the recent cases of conflict was with the government of Goa, where the NGT has banned the sand mining in the state, and the government of Goa has opposed this decision of the NGT, stating that they have exceeded their jurisdiction in this particular case. The second issue is with the number of members which are appointed in the National Green Tribunal. The tribunal is working with only 7 members as opposed to a maximum limit of 10 members. And also, according to the recent data, the regional benches of the tribunal have been vacant for 2 years and are now operating through video conferencing. So there is an urgent need for filling the vacancies that have been pending for 2 years now. And also there is a clause in National Green Tribunal Act 2010 as per section 14 clause 3, which deals with limitation that the complaint regarding environmental protection should be filed within 6 months when the cause of action arises, and this time period can be extended for another 6 months only in exceptional cases. But it is pertinent to mention that this provision fails to envisage the possibilities of long-term effects of environmental damage. It does not acknowledge that there are certain instances wherein the effects of the environmental degradation take time to surface. The most relevant example is that the harmful effects of the use of radioactive substances. Also, the jurisdiction of this National Green Tribunal is restrictive, as it only deals with 7 acts, which are the Water Prevention and Control of Pollution Act 1974, the Water Prevention and Control of Pollution Cess Act 1977, the Forest Conservation Act 1980, the Air Prevention and Control of Pollution Act 1981, the Environment Protection Act 1986, the Public Liability Insurance Act 1991, and the Biological Diversity Act 2002. So the NGT does not have jurisdiction to entertain the petitions under Wildlife Protection Act 1972 or Indian Forest Act 1927. So consequently, the major drawback of this limitation is that a person cannot approach the National Green Tribunal for every environmental issue. And for instance, the NGT cannot admit a suit for cutting off trees in a forest, even though it is related to environment. Also, there are the NGT decisions are often being challenged in various high courts under Article 226, with many asserting that superiority of a high court over the NGT, that and claiming that high court is a constitutional body while NGT is a statutory body. So this is one of the weakness of the act, that it has failed to mention the clarity about what kind of decisions can be challenged. And even though according to the National Green Tribunal Act, its decision can be challenged only before the Supreme Court. So in conclusion, I would like to mention that the establishment of the tribunal was undoubtedly a noble step in addressing environmental disputes in Indian society, but every step come with its own loopholes and challenges. The tribunal is facing a severe crunch of manpower and lack of resources. It is also not properly equipped to address the modern time issues related to environmental protection and conservation, and these loopholes are need to be addressed, as there is a need for more autonomy and to widen the NGT's scope for effective protection of environment in balance with human development activities. Thank you.
Shreya, can you hear me?
Yes, sir.
So about jurisdiction, one of an issue that I would like to put on record is that you see every body, that constitutional body or statutory body, has its own history which determines its jurisdiction, you know. So if you recall, the first major environmental protection law that we had in Water Act, right? Section 26 of Water Act talked about some kind of a body, you see, to which an appeal could be made if a particular, you see, consent is not delivered by a pollution control board, right? That kind of a body was never appointed by the governments, right? So therefore, some kind of a midway where you see you have a body like this, as well as you see, appeals can go to one single body. So that's how NGT came into play. Therefore, you see, Forest Act and the Wildlife Protection Act remains out of its reach. Now that contradiction is there, but the reasons for its limited jurisdiction is evident. You read section 14 read with 29, and you know there are a lot of other you see limitations as well on the jurisdiction of NGT. I mean, even with reference to the jurisdiction given to it. So there are a lot of this is something which has to be looked into in a separate research work, that you see whether this limited jurisdiction serves the purpose of NGT or not, right?
Yes, sir.
But thanks for a good presentation. We can move on to the next presenter, please.
Thank you, sir.
God bless you.
Thank you, sir.
Next up, we have Mr. Rahul Kumar, speaker on judiciary and sustainable development of environment.
Yes, next is, who's next?
Parth is probably.
I think there's some issue, network issue.
Yeah, next up, we have Mr. Rahul Kumar.
Shambhavi ma'am?
Yeah, I'll just coordinate. Just 1 minute, please.
Hello, I'm audible. Hello. Hello, I'm audible.